Hello, this is David with Stupid Things People Do and what we can learn from them. Today we're going to talk about workplace misconduct. We basically always talk about workplace misconduct, but today is special by merit of raw volume. Meet James. James is a 62-year-old who worked for River Forest Incorporated. James is not his real name, but we're going to do the anonymity thing here. And fun fact, James was the second most popular name for baby boomers born in 1956. If he had been born exactly 4 years later, we'd be calling him David, which would have made for the most confusing stupid things ever. Anyway, James worked for River Forest Incorporated until one day he quit. And the list of reasons he quit is quite long. It's about 1,000 lines and contained lovely entries such as Walmart greeter, grandma, old B word, and inquiries such as, "Are you still alive? What the F?" In other words, James was being viciously harassed for the egregious crime of being older. About 12 different employees were in on the bully the old guy to death plan, and when insults weren't enough, Team Aggro-psychopaths took to sabotage, defacing his workstation, zip-tying his tools together, gluing his cabinet shut, exposing the wiring on his old coffee maker. The list goes on and on. Reading the Justy report, it basically sounds like they watched the movie Carrie and got the wrong idea and decided to reenact the behavior of the bullies, but with frat boy style torments. Welcome to River Forest Incorporated, where every day is hazing day. Now, James didn't just sit there in silence and take the bullying. He really did try to report, but HR ghosted him. His supervisor dealt with the bullies by doing what amounts to nicely asking them to stop, meaning they threatened no real consequences. If you've ever been to middle school or read the comments section on YouTube, then you can guess how effective that was. From 2017 through 2018, James kept trying to get help, and HR did about as good a job at stopping the bullying as a family of Amish bakers would at stopping the Mongol hordes. The final straw came in 2018, when a supervisor joined in the fun, quipping, "Dang, James, you're still kicking? You got one foot in the grave and the other on a banana peel." James quit that same day and filed a complaint with the EEOC. And this is where things get nuanced. See, River Forest hadn't technically engaged in retaliation. They didn't fire James. And since James wasn't being persecuted by managers, Forest River wasn't strictly liable for the misconduct. And now, for people like me who needed to look that up, strict liability means someone is liable for something regardless of their intent. Fortunately for James, there's also this thing called constructive discharge. No, it's not a sinus condition. It's a legal theory. Constructive discharge theory applies when a workplace has become so intolerable that a reasonable person would feel compelled to quit. It's a bit like cat's paw theory. In our previous conversations about that, leadership had been manipulated by an employee into acting in a discriminatory way. Only in this case, instead of being manipulated, in constructive discharge theory, leadership is considered to have acted by proxy when they allow an environment that is so egregious it functionally forces the employee to fire themselves. So to use an analogy, if you set fire to your coworkers in an attempt to make them leave, you can't then argue they left of their own free will. It's a tricky approach to James's problem, though, because the burden of proof for this legal theory is way higher than your standard hostile work environment lawsuit. The reason is you have to be able to answer the question, how much is too much? Such as I set me on fire. And then you need to demonstrate that any attempt to get help would have been futile, such as management hid all the fire extinguishers. So despite the aggro-fratbroy culture, Forest River Incorporated was actually looking pretty good on defense. Initially, the district court threw the case out, declaring that what James suffered wasn't nearly as egregious as other cases, and that he should have gone to management for a 6th or 7th time. And, of course, James appealed, and the 7th Circuit Court concluded that yes, in fact, 1,000 insults in 1 year is a lot, and turning someone's coffee maker into an electrical death trap is a bit extreme. Well, they didn't say that exactly, but 2 of the 3 judges concluded that enough is enough. Well, kind of. The judges didn't technically say the behavior was egregious. They just determined that a jury could and should decide on whether or not the behavior was egregious, meaning they reversed the lower court's summary judgment. As the judges described, our role is not to weigh evidence or resolve factual disputes. It is up to the jury to decide. And that is actually a really cool idiosyncrasy of U.S. jury trials. Judges do not decide the facts in the USA. They just interpret the law. It is the jury who is responsible for interpreting the facts. In this case, what is and is not egregious, and what is and is not futile. And I'm not on the jury, but after 5 different managers failed to help James, who's he going to call? Tortbusters? Actually, Tortbusters is probably a pretty good name for the EEOC. Quick aside, the lawyers want me to make it clear that what happened here is technically not a tort. For a tort, there generally needs to be some kind of physical injury. So like if James had actually been electrocuted by his rigged coffee machine, that would be a tort. We're just going tort busters because that actually sounds funny versus, I don't know, misconduct busters. It doesn't really roll off the tongue. Anyway, I mentioned cat's paw theory and how constructive discharge bears some resemblance to it. In both of these theories, bad actors are influencing the actions of others. In our cat's paw theory example, the bad actors were using misinformation to manipulate management into retaliatory actions. In constructive discharge theory, the bad actors are acting so egregious, combined with management's failure to act, that the victim is forced to quit. In neither situation has management technically engaged in retaliation, but in both situations, liability is generated as if they had. So, what could they have done differently here? I mean, other than stop crazed office psychopaths from torturing people. Well, this connects back to that whole whistleblower reporting policy thing we've been talking about. As a leader, you want to foster a culture of reporting misconduct at your organization. And in order to do that, employees have to have reasonable confidence that if they report misconduct, some kind of action will be taken. Frankly, it's astonishing that James still felt confident enough to continue to report harassment after the third or fourth time it was ignored. All it takes is ignoring one complaint to undermine the employee's trust in the reporting process. So, tandem with encouraging reporting, leadership needs to empower managers to take action. Now, this may mean escalating to the appropriate HR representative, or it may mean empowering managers to directly confront harassment. Likely it will mean both, as multiple channels are often necessary to actually prevent harassment. And finally, this story is the perfect example of what should trigger an investigation. I'm saying HR or member care should have stopped, looked, and listened. There were well over 1,000 documented age-based discrimination comments and physical, sometimes dangerous sabotage. Investigating the claims to determine the scope isn't just good practice, it's common sense. Fortunately, River Forest has made the mistakes so we don't have to. Thank you very much for listening. I hope you enjoyed the vlog, and I'll see you next time.